Good morning and good afternoon. Thank you for joining our webcast on Federal Trade Commission Antitrust Investigations, What You Should Know. This is the first of our three CLE webinar series offerings that we're offering this month from BakerHostetler. These three webcasts will deal with vital insights into antitrust issues and white-collar investigations that impact all of you in different ways. The first webinar is about the FTC, and that's what we're going to be talking about today. My name is Carl Hittinger. I'm a partner at BakerHostetler. I'm also the National Practice Team Leader for BakerHostetler's Antitrust and Competition team. And I will be the moderator today for this webinar. Three of my partners will be presenting today and talking about the FTC, Mark Schildkraut, Jack Forciani, and Dan Foy. And we'll talk more about them later. But first, Alex Schrager, who's our marketing manager, will talk about the CLE presentation itself and things you should know to make sure that you get proper CLE credit as you go through. Alex?
Great. Our program today will last an hour, and it's approved for 1 hour of CLE credit in California, Colorado, Georgia, New York, Texas, and Pennsylvania. New Jersey credit is available via reciprocity. Credit is pending in Florida, Ohio, Virginia, and Illinois. For all other states, attorneys can receive a certificate of attendance and electronic materials so they can file directly with CLE credentialing entities. During the course of the webinar, we'll share two codes that you'll need to enter into a brief CLE questionnaire immediately following the program's conclusion. The first one is up here on the screen. Once the webinar has ended, please look for a small pop-up on your screen. Click the close button for your CLE quiz to appear in your browser. Please make sure to answer all the questions if you'd like for us to submit for CLE on your behalf. If you have any questions during the presentation, you can type your questions in the bar on the right side of your screen in the questions area. We will try our best to answer them at the end of the program, time permitting. If not, we will follow up with you after the webinar to answer any of those questions. We will also provide our contact information at the end of the program, so you can contact us at any time with comments, suggestions, concerns, or questions. We will also send an email to everyone in the next day or two with a link to a recording of the webinar. We also have up here a list of all of our presenters as well as their contact information.
And the next slide, Alex. Again, this is Carl Hittinger. The next hour, we're going to talk about certain subject areas concerning the FTC. First, we're going to talk about an overview of the FTC Merger Review process and practical insights that we can provide to you based on our extensive experience before the FTC over the past several decades, literally. We're also going to talk about the FTC investigation process, aside from mergers, where the FTC is investigating in a civil capacity possible antitrust violations under either the Sherman Act or the FTC Act. We're not going to talk today about consumer protection. That's an issue for another day. We're also going to try to share with you what we think are the top antitrust priorities of the new commission. What is the commission looking at? What do we think they're going to be looking at over the next several years? How to best handle those, either in a merger context or an investigation context or related litigation. And so let me start first by talking about the FTC. It's a brand new FTC. We have 5 new commissioners on the FTC. It's maybe the first time since 1915, when the FTC opened its doors, that we have 5 new commissioners at the same time who have been appointed over the past 2 years by this administration. There's 3 Republicans and 2 Democrats. One of them, the Democrat, is not a lawyer. You don't have to be a lawyer to be an FTC commissioner. That person is a consumer advocate and has experience in that area. But all 3 Republican and the 1 Democratic commissioner all have extensive antitrust experience. They're all experienced antitrust lawyers. They're not what we would call, political appointments. No disrespect there, but these are trained antitrust lawyers who have been in private practice and been prosecutors and been at the agency and have extensive experience dealing with antitrust issues. The voting so far on with these 5 commissioners has not really been on party lines. It's not 3-2 decisions. There have been some dissents by the Democratic commissioners, more so in big tech cases and also on non-compete clause issues. They have a different point of view on that. But many of the decisions have been a consensus decision by all five voting together. There was a director of the Bureau of Competition, Bruce Hoffman, who was appointed by the new commissioners 2 years ago. He just left. No explanation given, no reason to. But there's a new director of the Bureau of Competition as an acting director, Ian Connor. Again, a very experienced antitrust lawyer, as was Bruce Hoffman, and he will be leading the Bureau of Competition going forward. Over the last 2 years, the FTC has been busy with these new commissioners. They've contested the 42 proposed mergers. 20 of those deals were either restructured or abandoned. And the FTC says that they've tried 9 cases in the past 2 years, and they said were successful, whatever that might mean. So there have been some aggressive moves by the FTC, which our representatives will be talking about in more detail. And other changes to the FTC in particular were the creation of a new division, the FTC Technology Enforcement Division, that was created by the commissioners to look at issues in that industry. So with that, I'd like to introduce our first presenter, Mark Schildkraut. Mark joined us just recently. He's a very experienced antitrust lawyer. He, as part of his career, was an assistant director of Bureau of Competition at the FTC, and since then has extensively litigated against the FTC in a merger context, an investigation context, and gone to court against them. And so he's going to be talking about the merger review process. Mark?
Thank you. Thank you. So today I will be addressing the FTC's merger enforcement, but I'll also make some comments on the difference between the FTC and DOJ. We'll have another session on DOJ, but you've got to talk about this in terms of mergers because there are some differences that matter. One difference is that sometimes when new administration takes over, there's a more radical shift at DOJ enforcement than FTC enforcement. One of the major reasons for that is when you have a commission of 5 and only 3 can be from one party, you have other folks not of that party, in this case 2 Democrats, who are there to sort of police what the majority is doing. And so there tends to be more cooperation and less of a shift. This time around, the shift has rattled Antitrust Division employees. FTC employees rank the Federal Trade Commission as the best place to work among mid-sized agencies in the federal government. On the other hand, the Antitrust Division employees ranked it as the 375th best place to work among agency subcomponents. And that's out of 415 subcomponents analyzed, so it's down near the bottom. It also actually came in 19th out of 20th within the DOJ. I think there are reasons for that, but they're somewhat anecdotal because you can talk to staffers. But I think some of the reasons may have to do with a feeling among the staffers that the Antitrust Division has gotten somewhat more political, and that may have something to do with it. So many antitrust practitioners prefer the Antitrust Division investigation to an FTC investigation for reasons I will explain, but this may not be true across the board this time. So, for example, I think AT&T, which had an acquisition that was challenged by DOJ, would have probably preferred the FTC. The staff at DOJ at the time was working on a consent order that would have been a traditional kind of order for vertical mergers. But the head of the Antitrust Division basically told his folks to go to court, which they did, and then they lost. And it's not probably true of marijuana suppliers. There are actually ongoing investigations now of mergers between marijuana suppliers, and I know there are folks at the DOJ who thinks that's political as well. And so that may have something to do with why we get the rankings we have now. So let's start on the merger review process. So it all starts with an HSR filing. That's typical, and the FTC administers HSR filings. Sometimes, as a matter of practice, parties will notify agencies before filing in order to expedite the process. You'll just call up on the phone and say, who should I talk to about this deal? And you'll do that when you think the agency is going to understand the deal, know about it, is going to have questions, and you're not going to avoid those questions by waiting. Other times, merging parties do file and duck, though I think the duck on the screen is not ducking enough to avoid a second request here. The reason you would do that is because sometimes the overlaps are rather obscure. The filing ends up on somebody's desk, and you may not have enough time to dig into it enough in order to know that there's a problem. So people do that. And then there are times when you don't have to file, but nevertheless, the agency finds out about it, usually through a complaint by a third party, and starts a review in any event. Sometimes the deal has even been consummated when they start their review. So I'm not going to spend a lot of time on the thresholds. You've got this, so you can look at it later. The one thing I do want to say is that the thresholds change every year. They've been going up on a regular pace. And it was a number of years ago that anything over, I think it was like $10 million had to be filed. So they moved that up to $50 million, and the size of transaction threshold has gone up from there every year, and that's why we get the kind of numbers you see on the screen there. So once you've filed, one of the first things you have to worry about is gun jumping, and that means partial consummation, of the merger before the expiration of the HSR waiting periods. And there are basically two criteria. One is known as beneficial ownership, which is governed by Section A of the Clayton Act, and the potential acquirer can have the right to gain the value of the underlying assets, the risk of loss, the right to receive distributions, the right to vote the stock, to designate management, discretion over investment decisions. Section 1 of the Sherman Act also comes into play here, where you're not allowed basically to do things you wouldn't be allowed to do if you were two independent competitors. But not everything is gun jumping, because the agency sort of understand that you have to do things in the acquisition agreement to protect the core transaction. So a veto power by the buyer over certain things like extraordinary acquisitions, dispositions, or extraordinary contracts are things that the buyer can have a veto power over. Transition planning is okay as long as the transition planning only relates to post-acquisition events. And you have to still be really careful about that, because if you're two competitors, you don't want to, and the FTC doesn't want you to be exchanging sensitive competitive information. And sometimes what you do is you put up walls. Folks who who are involved in transition planning may be people who are not line people who are involved in the competition to begin with. You want to be particularly careful about gun jumping if you're concerned that the FTC will investigate the acquisition, because that's how they usually discover it. It can also slow down the investigation of the merger if they have to start an investigation of whether there's gun jumping. After the filing, we have this agency clearance process. And either of the agencies could investigate almost any acquisition. There are a few exceptions to that relating to common carriers and others. But by and large, either agency can do that, and they have to decide which one is going to do it. And the primary criteria for deciding that is typically who has the experience in that particular field, and they will go through that. and try to resolve that. Now, there has been some contentiousness in this process recently, and in fact, this has been noticed all the way up to the Senate, where Senator Mike Lee has basically noticed this problem between the agencies. And it can be a problem for you if you have a deal and you're waiting for waiting for the agencies to decide. Sometimes what happens is the parties end up presenting their arguments to both agencies. Typically, there'll be a joint session with the agencies when this is happening, and the agencies are still trying to decide whether there is going to be clearance or not. You sometimes have to decide whether you want to go through that process or not. But usually if one of the agencies is asking, they will tell you they don't have clearance yet if that is true. And by the way, until you have clearance, you cannot talk to third parties about the deal, but you can talk to people who volunteer. So the parties can volunteer. Even a third party can come in and complain. You just can't solicit that. So that can take some time. And there have been times second requests have been issued on the last day because clearance was only issued on that day. So this can occasionally be problematic. The early phase of the investigation, there's 30 days to make a determination as to whether to issue a second request, except if there's a tender offer, in which case it's only 15 days. Parties can brief the investigating agency to try to avoid a second request if they know that the agency is interested. You are permitted to pull and refile, and that will extend the 30-day waiting period for another 30 days. And parties will do that sometimes to avoid a second request or limit the scope of that request. If you do that, you get one chance to pull and refile without having to pay a filing fee again. But you will have to update your filing. So if there are additional documents you have to provide, you're going to have to provide those documents. Advanced preparation can be pivotal in avoiding a second request. I've often prepared multiple presentations and white papers in advance of a second request in the hope of avoiding the request, though I'm just not going to throw them in over the transom. I'm going to wait and see what the staff is thinking before I provide anything like that. But it can be very important, and sometimes it's important not just to answer their questions, but to go beyond that and show them why you don't think a second request is warranted. So the agencies can issue the second request if they believe further investigation is warranted. The second request is a combination of a document request and interrogatories. You've got as long as you want to answer that request, and then the agency has another 30 days to decide what to do. Second request can require the parties to submit millions of documents. A 2014 survey indicated a range for complying between 4.2 million and 9 million. The investigation during the second request period is interviews, depositions, review of documents, draft declarations, review of white papers, preparations for recommendations to the commission. The FTC can, when it decides, can try to take no action. They can take no action, thus permitting the parties to consummate. They can try to resolve the anti-competitive problems through a consent decree, or they can try to stop the consummation through a preliminary injunction. The preliminary injunction in litigation usually takes a few weeks, but it has sometimes taken months. It's like a full bench trial. If the court issues a preliminary injunction, the parties invariably just pull out. The commission, on the other hand, has the right, if a preliminary injunction is issued or even isn't issued, to continue in the administrative process to basically make a determination. I should correct that. If a preliminary injunction is issued, the commission has to continue its administrative process because the preliminary injunction only stops the acquisition for the period of time for the administrative litigation. I'm going to give you some statistics on what happens in these deals. If you get a second request, they've always challenged the deals about 60% of the time. During the Obama administration, it was 83.2%, and in the last fiscal year, 2018, the FTC and DOJ challenged 87% of the time. Challenge in this case includes consent orders. It's not just going to court. One third, I believe, something on that order of over time of second requests have been in healthcare and pharmaceuticals. But in the first half of 2019, the technology industry accounted for 40% of merger review process. And if you look up above, one reason folks sometimes prefer the DOJ is their second request process goes faster, averaging less than 10 months, while the FTC is taking more than 16 months, and only one in the first half of 2019 lasted fewer than 10 months. So one thing, I didn't mention 4C though, but 4C documents are documents you have to submit as part of your filing, and they are documents to directors, by directors, to officers, by officers. And the FTC gets to look at these things, and if they see something that looks problematic, you're much more likely to get a second request. So you want to try to minimize the bad documents, and can be worthwhile to coach employees on document drafting. And you just look at some of the things over time that folks have said, you can see why there have been litigation. So Whole Foods, they talked about, by buying them, the target, we will greatly enhance our comps and will avoid nasty price wars. In Chicago, Bridge and Iron, we will be the 900-pound gorilla. That gorilla doesn't look very ferocious to me, though. I don't know. Evanston Healthcare, the addition of the acquisition target will substantially improve our leverage. Polypore, we will completely control, and then several markets. So good thing not to try to have documents like that. In fact, it's a good thing to have to coach employees through various sessions about the things not to put in documents. So that's where it stands on merger review at the FTC these days. Carl?
All right, Marco. Thanks very much. Appreciate it. I'd like to introduce my partner, Jack Fornaciari, who's going to talk about the FTC merger process based on insights that he has gained through his extensive experience dealing with the FTC on various deals and investigations and litigation. And so I can turn it over to Jack. Jack?
Good afternoon, everybody. My objective here in this presentation is to give you some practical observations about what you can expect. Many people don't expect what they're going to get at the FTC. So we're going to talk about a typical merger where your client wants the merger to close as soon as possible. If it's a complicated merger, and if you, in your pre-filing work, have uncovered issues that are clearly going to be problems, it's a good idea to think about hiring an economist as soon as you can to assist you in positioning the way you want to go. I found that in complicated mergers, the best thing to do where your client is dying to have a quick closure is to call the FTC first, as Mark referred to it, and actually go down and make a pitch before you file, so you can help the staff understand what the deal is all about. At some point, in a lot of acquisitions, clearly not the majority, the staff is going to have a competitive problem. Whoop. I'm going to keep talking, even though we had a little problem with the slides. I think people might have copies of the slides. Once you have a competitive problem, you have to make a decision whether you're going to offer a remedy or not. Usually, this decision is kind of pre-digested by the client in getting ready to make the filing and to make the initial encounter with the FTC. It's always good, if there's going to be an issue, to talk it through with the client and actually have the client decide early on the best way to go in the event that you can't persuade the commission to clear the merger without some kind of remedy. Unlike the DOJ, the FTC and the Bureau of Competition has a special section called compliance. In compliance, the staff is expert on fashioning remedies, and when you get into the compliance situation, you've offered a proposed remedy, and you will begin to discuss the acceptability of the remedy with the compliance section, as well as the Bureau staff who have investigated the merger. At this point, the chance or the hope of a quick closing really is not going to happen. It may be several months, it may be longer. But at the FTC, the vetting of a proposed merger, divestiture, is really serious business. Recently, there have been a lot of publications in which the divestiture remedies passed by the FTC have been the subject of criticism. Some of them have been claimed to be failures, and so this has put a lot of pressure on the agency staff to try and get it right. The staff will consider almost every factor you can imagine in determining whether or not the divestiture is going to work or not. So it's critical, if you want to move this process along, to have as many discussions as you can have with the staff so you get their feedback. It is extremely important to be proactive with the staff and to make sure you understand what they're thinking. Many companies think that they're going to divest the assets they propose to or would like to. My best advice to you is that's not going to happen immediately, and you're going to have to negotiate. So you might as well negotiate with draft documents because there'll be many changes. There's two critical decisions, I think, that you have to make when you're proposing a divestiture remedy at the FTC. One is, who's the buyer? And the second is, what kind of a divestiture are you going to propose? The buyer is extremely important, and recent discussions at the FTC have focused on the value of the buyer in terms of the success of the remedy. The FTC will have questions about if you line up the proposed buyers, the FTC will have questions about how they were selected, what their status is, are they in the market, out of the market, upstream or downstream participants in the market. So of course, the buyer will be interviewed, and the FTC might itself suggest possible candidates to you. One critical thing about any buyer is they understand the industry in which you're going to make the divestiture, and that they have the financial strength to carry a divestiture. So when I talked about what kind of a divestiture you're proposing, there is a inclination at the FTC that divesting an ongoing business is much preferable than to divesting a set of assets that previously were not operated as an ongoing business unit. This is because the risks are less with an ongoing business. If, however, you can't do that and you propose to offer as a divestiture a set of assets that you think will restore competition in the market, you can expect to have a lot of scrutiny, a lot of questions, and the inclination would be to have an upfront buyer, because an upfront buyer theoretically will limit the risks involved in a successful divestiture. The risk will be shifted to you to make sure you get the buyer in place. The divestiture agreement and all of the associated agreements that are associated with it have to be reviewed and approved by the staff before they'll recommend them to the commission. So in reviewing the divestiture sales agreement with the divestiture buyer, the staff will have a lot of questions and will want a lot of evidence. They will look at a tremendous amount of information to determine whether they can make an assessment that this proposed divestiture will be successful. You're likely to get requests for many revisions. I have to say, in all honesty, sometimes if there's more than one compliance officer working on it, you might have conflicting suggestions by different staff when you're speaking to them separately. It's not when you're negotiating the divestiture with the FTC staff. It is not going to be a sufficient proposition that you've talked it over with the proposed buyer and they're satisfied with what you're doing in terms of certain assets or certain transition agreements. The staff will make its own decision because the staff is of the opinion that a buyer is willing to accept certain risks to get the assets, but the staff is not willing to accept those risks. So when you're divesting assets, the staff will require assignment of all the contracts needed or used in the business, even if the buyer indicates he doesn't have a need for them or an interest in the assumption of the contract. This will actually go down to assigning contracts for copy machines. The staff will second-guess buyers' decisions regarding post-closure assistance, as, for example, the length of time for a supply agreement or the amount of supply that your client is going to have to supply to the divestiture buyer in order to get their business up and running. The staff might require additional assets. Recently, I had an acquisition where we proposed to divest a certain asset, and there were reserves in a different location, and the staff demanded that those be included in the divestiture, even though the buyer didn't think they were necessary. So some examples of the kinds of items the staff will want you to share with the divestiture buyer is customer lists, competitors, and vendors. So the staff expects you to help transition customers dealing with these assets and introduce them to the divestiture buyer. It will also do the same with not just key inputs to the manufacturing process, but to all vendors. The staff will want to know about the intellectual property and what needs to be transferred or shared or licensed with the divestiture buyer. In short, the staff expects the respondent, or the proposed respondent, you, the buyer, to help the divestiture buyer to become successful. One thing that's not well known is that the divestiture sales agreement, along with whatever ancillary contracts are with it, once approved and once recommended to the Commission, actually become part of the consent decree. They're not in the consent decree, but they're referred to and attached, and they are part of the consent decree. The FTC has filed post-closing actions to remedy what it considers a breach of the divestiture agreement. So recently, I had a divestiture buyer complain to the FTC that my client, the acquiring company, had breached some of the reps and warranties in the sales agreement. Of course, this resulted in a further investigation and more money and more time, but the assets were already purchased. Here's an illustrative list of the kinds of documents you're going to have to negotiate or propose. There's going to be a complaint, consent decree, and an order, an agreement containing the consent decree and order. One thing about this process is there's an initial approval of the consent decree and order, and you can close after that as long as there's an order to maintain assets in a whole separate order. And the FTC can theoretically require you to pull it or change it, so there has to be a rescission term in the agreement. 60% of the time, there's a monitor agreement where you're going to have a monitor who is monitoring the divestiture and the compliance reports and who's there to make sure things operate smoothly. There's always a transition services agreement, and there's always a supply agreement. So I think the best thing to do in a complicated merger is to be proactive with the staff and to be a realist when there's a competitive issue that you feel is going to be a problem, because you don't want to have a lot of mini trials on issues when you're trying to close quickly. And those are the insights I can share with you this morning.
Jack, thanks very much. It was very helpful. We've now talked about mergers. Both Mark and Jack have gone through the top to bottom of that, the insights, their experiences there. That, of course, is something the FTC handles all the time, as does the DOJ. Now we're going to shift over to investigations. As some of you know, the FTC also has the right, statutory ability, to investigate violations of the antitrust laws, both the Sherman Act and the FTC Act. And all four of us have done battle with the FTC in these investigations. The penalties were severe, and they were very costly cases to deal with. So my partner, Dan Floyd, is going to talk about FTC investigations and some current trends there. Dan has extensive experience both as a civil antitrust litigator and litigating against the FTC in all sorts of matters over the past many years. Dan?
Thank you, Carl, and good afternoon, everybody. I'm going to focus today on some of the investigation trends at the FTC and some related points. As Carl mentioned at the top, the current slate of commissioners were all newly sworn in the same year for the first time ever since the FTC was established. This slate of commissioners is historic in some other respects. And to illustrate, I thought I would mention a couple of those notable points. One is these commissioners represent a very broad age and experience range, with a millennial for the first time as a commissioner, and a commissioner who started working at the FTC in the 1980s before many millennials were even born. We also have a commissioner with very deep interest in digital economy issues and consumer advocacy, who is not an attorney, although that is not in any way a disqualification. And some other commissioners who have a long background of having worked for the federal government, at the FTC, for example. And I mention this because any discussion about FTC investigations, I suppose, has to start with the consideration of the FTC commissioners, because they ultimately decide the investigations and the resolution. Despite a complete turnover and historic diversity, the Commission so far appears steady in its approach to competition, with, as we'll see in a minute, a focus on many of the same issues as their predecessors. But before getting to that, I wanted to say a few things about the investigation adjudication process itself, because it also provides some helpful context. The FTC's Bureau of Competition has the discretion to seek enforcement of antitrust law through either an internal adjudicative process, namely a hearing by the FTC's ALJ with review by the commissioners, which is sometimes referred to as a Part 3 proceeding, or by filing in federal court. The FTC over time has compiled an incredibly strong win-loss record for enforcement actions done administratively. So much so that a couple years ago, then Commissioner Olhausen published an article considering whether the ALJ process is, quote, rigged and without, quote, due process. Despite this home field advantage, the FTC has an inclination to file enforcement actions in federal courts rather than to do them in-house. People often wondered why they do that, and I think there are a number of strategic reasons for the FTC to file in federal court rather than pursue an administrative remedy. One of those reasons, rather cynically, may be that the actions filed in federal court make available restitution and disgorgement, which in some cases can be hundreds of millions of dollars and have led to some settlements of over $1 billion. Going on to the next slide, although there may be a technical difficulty here. Since the new commission has started up, it has placed its focus on certain areas, often involving industries that are concentrating or evolving. The current commissioners have identified several industries that are of particular focus for investigations. This year, the Commission announced its intent to focus on high technology markets and closely monitor developments in the technology sector. The Commission also established a technology task force, which Carl mentioned in the beginning. This task force has said it will examine industry practices, conduct investigations, participate in merger reviews, and that it will even go back for retrospective reviews of consummated mergers. This is not the first time the FTC has announced a task force of some kind, and some people may say to themselves, will anything happen as a result of this task force? And the answer may be yes. The FTC appears to have focused on some of the biggest of big tech. Some of the biggest companies in this sector have recently acknowledged in filings, FTC filings, that they are under investigation. And the FTC chairman, in an interview just a few weeks ago, said the FTC is reviewing past tech mergers for harm to competition. So there seems to be a likelihood that these investigations will actually kick off and could go somewhere. Another industry the FTC has identified for focus involves healthcare. Now, FTC has been focused on healthcare for a long time, at least 10 years, following several years of some losses in their hospital merger cases. But everyone seems to be concerned with healthcare costs, and this focus by the FTC appears to have broad appeal and support among Congress, which, of course, funds the FTC. Pharmaceuticals is another industry that has been identified for a focus of investigation. This is also not a new one. This has been focused for at least 20 years. But with the 2013 decision and activists arguably re-energizing the FTC's enforcement, at least in the paper delay context, the current commission appears to be continuing with its ongoing focus on pharmaceutical patent, reverse payment cases, and there are a handful of these cases, I understand, being litigated today, and some are being investigated today. Beyond industries, the FTC has also in the past focused on certain issues, and the current commission appears to be doing the same here as well. The biggest issue is probably big tech, as I mentioned earlier. The biggest industry is probably biggest tech. The biggest issues in that industry may be the acquisitions within the big tech area. The FTC has identified several weighty issues for big tech. One of them is whether these companies have acquired startups or potential competitors as a way to suppress the emergence of competition. And of course, another issue is non-compete provisions and the no-poaching type agreements. These have also been part of the FTC's focus for a few years, and recent statements by staff indicate that they, along with the DOJ, intend to keep on top of these issues. Now, it's probably a risky game to guess where the FTC's focus in investigations will go in the future, but there's a few areas that I think may be safely assumed. Big data undoubtedly will become more of a focus as more products gather data about us, and more companies compile this data during our lifetimes. There's a whole subject about group algorithms, artificial intelligence, machine learning, and all of this area collectively appears to be headed for a collision with antitrust law at some point in the future. The FTC has had a number of panels about this, and Mr. Hoffman, the recently departed Bureau of Competition Director, has said that these technologies raise clear competition concern. I'll just quickly go through some of these other possible future focuses. One could be vertical mergers. This, of course, has gotten a lot of press because of the DOJ's work. on the AT&T Time Warner merger challenge, whether the FTC takes the same tack, yet to be seen. The FTC recently has approved vertical mergers with conduct remedies, which is the type of remedy the DOJ is not receptive to today. In 2015, BakerHostetler hosted a symposium on Section 5. There we had judges, professors, practitioners all talk about the state of Section 5. It was taped, transcribed, and it is available on the internet and YouTube, and we of course recommend it to everybody. Now, one of the discussions at that symposium was whether there was a need for a statement by the FTC on what is a Section 5 violation. Section 5 declares unlawful, unfair methods of competition. And what that exactly means is a subject of a lot of debate now, as it was in 2015. The FTC did ultimately issue what it called a statement of enforcement principles. And it describes what types of conduct could be pursued under Section 5. That statement, however, is you might find to be not that enlightening. It says that the FTC will consider public policy and that conduct will be evaluated under a framework similar to the rule of reason, which itself is not definitive. So a question for today is, has the statement of principles, has the current commission in its implementation of Section 5 resulted in any changes? Are there any developments in Section 5 since the statement? And I think that question is fairly answered by saying not really. In fact, it could be argued Section 5 may be of even lesser relevance to the FTC today than it was in 2015. Some of the bigger cases brought by the FTC recently were brought under Section 2 when they could have been brought under Section 5. Of course, it would be expected that the current commission would continue to use Section 5, much like past commissions, for situations where the conduct at issue doesn't really fit into Section 1 or 2. And, of course, the FTC today is doing that. There are patent-based antitrust cases and litigation that is ongoing that are premised on Section 5. And finally, to the extent Section 5 offers the FTC more flexibility than Section 1 or 2 of the Sherman Act, one would expect to see Section 5 continue to be applied in cases where there's overlap of consumer protection and competition laws. Finally, I mentioned that I would talk about investigations and some related points. The related points are here. Our clients often come to us and say, we have a question we'd like to run by the FTC, what can we do? Or we think somebody in the market is doing something inappropriate. Can we take that to the FTC for some kind of relief? And those are good questions, and we wanted to close with just a couple points on that. The short answer is that there are various ways to approach the FTC with inquiries and complaints, and each has some pros and cons. One is an informal communication. This could be as simple as calling a staff contact you know to see if there's any interest in pursuing the issue. And this may be a productive approach if the person you know at the FTC has an interest in the issue at hand. An advantage to this approach is that it doesn't require much investment or even disclosure, but a disadvantage is that there is no guarantee of any follow-through by the Commission. There is, of course, a more formal way of approaching the FTC. The FTC and the Bureau of Competition specifically do accept complaints in writing from counsel. This may be a better way to initiate a response from the FTC and can also maintain the confidentiality of your client, which is often a concern when your client is perhaps raising an issue with a supplier or customer. But a downside to this still is that a complainant may ultimately become a participant in a case if and when the FTC staff investigates for information. The identity of the complainant may become known by the other participants in the market. And finally, there is the option for advisory letter opinions, which are issued by the FTC or the Commission. These often are time-consuming to prepare and often require even more time waiting for a response. And when you do get a response, it is non-binding. So this has some even bigger cons. Carl?
Very good. Thank you, Dan. That was very helpful. I don't see any questions. Please, this is the time to ask the questions of our panel members. While we're waiting for that, let me pose a question to all three of you. This kind of touched on something Mark got into, but please all weigh in on this. It seems that, lately there have been some turf wars between the Department of Justice and Antitrust Division and the FTC over who is going to either review a merger or who is going to investigate a potentially antitrust violation. And I think you've all talked about how those things are often divvied up through the two agencies in a conciliatory way, but sometimes that isn't working and political considerations may come into play. So please provide some advice of best practices of how best to move a merger or even an investigation in the right direction without looking like your agency shopping, so you get a good result for your client.
So if it's an investigation of conduct rather than a merger, you may not even know that there is a clearance battle. So you may not be able to do anything about that. That would be unusual, in fact, if you did, because in theory they're not allowed to talk to you until they have clearance. But in the case of a merger, you can volunteer to talk to both agencies. And sometimes those discussions are held jointly, but sometimes not. And I suppose you could do a better job explaining why there's not a problem to the agency that you don't want to review the acquisition. It is very, very hard to steer an acquisition between the agencies. Some people have thought they've done it, but it may just have been a coincidence that they got what they wanted.
Okay. And let me pose another question that kind of goes to something that, Jack, you talked about, being proactive and trying to anticipate what the FTC might be looking for in terms of divestiture or other kind of remedies, and to kind of propose that to them and try to work through that before they try to do that. Of course, that raises the issue of, I guess, Mark talked about gun jumping. You are dealing with, competitors after all. How do you best, navigate that in terms of, coming up with solutions without actually reaching out to the third parties and trying to, behind the FTC, work out some kind of deal or divestiture? Or are you better off bringing them into the process and having them be the coordinator? How to best handle that, Jack?
So I think it's always better for the client to just try and decide who is the best candidate for a divestiture. And usually the in-house counsel can get involved in helping gauge the interest of the companies that management thinks are probabilities. If it gets beyond that to actually discussing interest, I think the best thing to do is have a clean team agreement, so there can be conversations over and above just surveys of interest by the in-house counsel. I think it's better, the client's better suited if it and knows more about the industry if it picks the 2 or 3 candidates that it can propose to the FTC staff, rather than having the FTC staff fumble around trying to find somebody.
Very good. And then finally, we're running out of time, but Dan, I just want to pose a question to you. You raised, importantly, the whole process, advisory letters. And we all know, having dealt with clients on this, that people are reluctant to go to the government and raise a question or an issue because they think they're red flagging something that the government's not going to find out about. And we all know that the government finds out about it anyway. So this is another example where Jack talked about it being proactive on something. So how do you advise clients who are reluctant to kind of let the FTC know something they're thinking of doing? There's no HSR requirement, for example, but they want to do something that could raise some antitrust issues. How do you best persuade clients that that's the right tack to take of asking for an advisory letter?
Well, the first hurdle for an advisory letter is that the client has to be, I would say, poised to take the action. The advisory letters are designed for situations where, prospective conduct and it's not hypothetical conduct. So I think it has to be carefully decided. I don't believe that there is a preference to approaching the FTC with a question, and it depends on the nature of the question, the likelihood that whatever the issue is will be found out by the FTC, or whether the FTC might already know, and then also consideration of what would be the results or the downsides, the remedies, the punishment, if you want to say that, about not going to the FTC and going forward with the conduct, and then the FTC finding out through some other avenue. So it's not a direct answer, because I don't think there's a one-size-fits-all answer to give you, but I think it's something that needs to be carefully considered in each instance, and that's what I would say.
Okay, I think it's a good answer. Obviously, as the circumstances. We've run out of time. The only question that came in is, how do I get copies of the slides? You will, after this is over, get copies of the slides. Alex, correct me if I'm wrong on that, but I think that will be going out to the people who participated. Last thing I just want to mention is, as I said in the beginning, there are 2 other webinars coming up. There'll be one next Wednesday, and then one the Wednesday after that. The next Wednesday webinar is about the Department of Justice, the Antitrust Division, cartel behavior, as well as other white-collar issues, FCPA, whistleblower issues, will be addressed by my partners next week, very experienced people with government experience as well. And then the third webinar, which is on October 23rd, is about state attorney general. We didn't talk about those today, but the state attorneys general are involved in merger activity, investigations, both antitrust and white collar. They are a force to be reckoned with, even more so than years ago. And we'll be talking about that in the final webcast with people who have dealt with state attorney generals, both in an official capacity and as lawyers for clients. So those are the next webinars coming up. Alex, is there anything you want to tell everyone before we sign off about next steps?
Nope, you all will be receiving an email in the next day or two with, as Carl had mentioned, a PDF of the slides, the recording, as well as links to register if you haven't already for our other 2 upcoming webinars in October.
Thank you very much, Mark and John and Dan. Excellent presentations. We hope it was of help to the people listening in, and we'll talk to you hopefully next week. Thank you. Bye-bye.
So do you have the same tie on?